everybody on the webinar today. It's Robert Bond here at Bristows. Data transfers post GDPR and Brexit and elsewhere is the topic. And this is a webinar version of at least one presentation that I have done for the Swedish Data Protection Forum. And we're delighted to be able to do this in conjunction with the forum. And with that, I'm going to hand over to Caroline to say a few words. Caroline.
Thank you, Robert. Yes, my name is Caroline Olstedt Karlström, and I am the chair for the Swedish Data Protection Forum. We are really happy about being able to provide you all with this webinar and this interesting discussion together with Robert Bond and his team at Bristows. The Swedish Data Protection Forum is a non-governmental and non-profit organization. We are the largest organization in the Nordics with over 700 members from a large number of both public and private companies and organizations. The forum was established in Sweden in 2012 in order to provide both the exchange of ideas between our members and also to provide knowledge regarding all matters relating to data protection and all those matters that do give us lots of headaches on a daily basis. We do this through, for instance, seminars, training days, and also a yearly summit in Stockholm, the Nordic Privacy Arena, a yearly Nordic event with over 400 participants. So this year we were also really happy to be able to welcome Robert to Stockholm. And we had the pleasure of welcoming him as one of the keynotes at the arena. And as Robert already mentioned, he has since then also participated in other networking events in Sweden, which we are really happy about. Robert do have an extensive experience in advising all kinds of national and international clients of so many different data protection related aspects, among others. So I'm really happy to give the mic back to Robert now. Thank you.
Thank you very much. And just a few admin points before I get started. The first is that you can send questions in using the question box on your screen, which I will deal with either as they come in or more likely towards the end. The webinar is being recorded so that should you or colleagues not be able to stay to the end, it will be available for download from the Bristows website next week, and we will also be able to supply a link to Caroline for the forum. We are going to do, if you don't mind, before we get started, I've got 3 polling questions which I will report on anonymously in terms of percentage answers, but we thought between Caroline and myself and Frederick that it would be useful to ask these questions just to get a feel for where you are. So if we could launch the first polling question, please. Okay, so do you think that the UK will leave the EU on the 29th of March, either with a soft Brexit or a hard Brexit, or a bit like me and half of the politicians? I have no idea. And looking at the results as you are kindly answering this, not surprisingly, the majority of you have no idea either. So the great news is that whatever I advise you in the next 40 minutes, I can't be right, and I probably can't be wrong. Let's have a look. Okay, if we close that one, it looks like 61 said I've no idea, 20% said hard Brexit, i.e. no deal, and 19% deal. So anybody's guess. So let's have a look at the second polling question if we can. And I put on here, do you share personal data between Sweden and the UK? Now, actually looking at the registrants, there are a good number of you who are in other Nordic or EU member states, and obviously there's a good deal of you who've got UK operations. So by all means, substitute Sweden for your Nordic country or your EU member state if you're not in the UK. What I'm interested in really is how much of the data transfers are coming into the UK at the moment. And it's just, people are still answering. The majority of you are saying yes, data is being transferred from an EU member state that you're in to the UK, but it's actually only just 54 or 55% saying yes and the balance saying no. Okay, thank you for that. And then the last question, which is probably the most important one, is do you have in place a solution to allow for personal data to be transferred between your EU location and the UK? And by the way, for those of you that are in the UK, it's the same question. Have you got something that will allow data to come into the UK if we are not in the EU? And I've put yes, no, and not yet. And thank you for answering these. It's changing all the time, by the way. The least percentage is no. That's good news, as in you're doing something. And it's roughly, yeah, okay, it's 41% saying yes and 40% saying not yet, and 19% saying no. So as I say, that's good news. And it means that what I am going to be talking about for the next 35 minutes is going to be of value, because I'm going to talk through where we are now, where we could be, what are the different directions that we could be heading in, and then give you some thoughts as to what might be that solution that allows data to keep on moving a nanosecond before Brexit and a nanosecond after Brexit. Okay, so GDPR, as you all know, expanded the options and procedures available for data transfers beyond what we used to have under the old directive. Of course, expanded the obligations to both the controller and the processor, has now enabled binding corporate rules, BCR, for controllers and processors, continues to allow for the use of the EU model clauses or standard contractual clauses, also provides that data protection authorities can develop their own standard clauses that can be then approved by the European Commission. Also approve codes of conduct. And by the way, you may well have seen within the last week or so that the European Data Protection Board have issued draft guidance on developing codes of conduct to address compliance, and there will be further guidance on codes of conduct and data transfers. There's also the idea of seals and certifications, much like the CNIL seal, which has been around for a while. And then there's the other contractual clauses authorized by a data protection authority with the so-called consistency mechanism, and that is where perhaps you try and negotiate a one-off arrangement with a regulator. So moving to the next slide, and apologies that this is very text heavy, but it's one that I've used for many, many years and recently updated with Brexit in mind, so that if you are sitting down there looking at how do we address our data flows, you may be within the European Economic Area, in which case there is no restriction on data flows, or you're outside, in which case you then start looking at, is it US and is Privacy Shield in place? Is it an approved country like Israel and Switzerland, Isle of Man and so on? Is it Canada where they have their particular regime? Or is it other countries? And I've now added in red, such as the UK, because we may find ourselves, if we're not careful, in a situation where we are just another country, in which case we then got to start looking at the solutions that are needed. So, sorry, if we can just jump back, please. Thank you. It is important to notice there that there are those different options if we were another country. And yet, of course, some of those, and I'll talk about it later, we're already seeing indications that the UK may not even be in a position to participate in approving binding corporate rules because we won't be at the table, so to speak. So if we just move on to Brexit, and then I will come back and talk around the flowchart I just showed you. We've got, as far as I can see, either a deal or a no deal. And from the percentages of the answers you gave, it's a roller coaster ride. None of us really knows where we might be on the 29th of March, or will it get extended? And as you know, on the 12th of March, next Tuesday, when in fact I'll be giving a similar presentation in Berlin, we're due to vote in Parliament again on a deal or a no deal. So probably none the wiser in another week's time. But what happens if we have a deal or no deal? Well, if there is an agreed deal by the 29th of March, then we know that until the end of December 2020, we have got an arrangement that will allow us to remain in the EU during that period. Nothing really changes, and the politicians and the regulators and the ministers get together and find practical solutions to all sorts of issues arising out of the movement of information, of goods, of people, and then of personal data. But what if there is no deal by the 29th of March? Then 1 nanosecond after 11 p.m. UK time, or midnight with you in Sweden, we're not there. We are gone. We are not in the EU. And then if we're not in the EU, we don't have any of the benefit of applicability laws, of jurisdictional regulations, and we have no privacy shield, because privacy shield is a EU and Swiss to US arrangement, but not a UK arrangement. So in the UK, we've already seen guidance through the Department of Commerce in the US and the Federal Trade Commission that if you're going to continue transferring personal data from the UK to the US, you need to make sure that the US recipient, if their Privacy Shield, has amended their Privacy Shield certification to include the words UK, or the initials UK and the words United Kingdom. And to the extent that the personal data that is going between a multinational via Privacy Shield includes employment or HR data, then we need to consider amending the employee policy to address the fact that the data is going from the UK to the US. We will also have issues such as we are not in the EU, therefore we are not, under the old standard contractual clauses, a data exporter in the EU. The UK, 1 nanosecond after we leave, will be a data importer. So all of those model contracts that you may have in place will not work. And to the extent that you have relied on the principles of free trade between the EU member states, as we're not in the EU, there is no free trade. So we know again that the guidance is there needs to be something in place to enable that data to continue moving, and probably standard contractual clauses, binding corporate rules if you are, of course, the beneficiary of BCRs already, will work. We know that the ICO has been told that any existing BCRs that are not yet finally approved, you will have to find another lead supervisory authority to take over the process should we Brexit without an arrangement. And here we are on the early March with not a lot of time till the 29th of March, and still none of us are sure what the end decision is. And then, of course, for those of us who are lawyers in the UK, who, of course, at the moment have the benefit of being able to appear before the courts in Europe, we have another problem too, which is there is no mutual recognition of qualifications. And so we ourselves as an English law firm have now opened in Brussels for precisely the reason of establishment and being able to appear before the European competition authorities and the patent courts and so on. So all sorts of businesses, even the law firms, are having to think, how do we deal with what happens with a no deal Brexit, a hard Brexit, because data, unfortunately, does not recognize jurisdiction, nor does it recognize boundaries, nor does it recognize points in time. So the data will keep on flowing, and potentially you will be transferring data to the UK from Europe unlawfully, and the UK will be receiving data unlawfully without something in place. So what is it that we do put in place next? Again, at the risk of repeating myself, here visually are the data transfer mechanisms pre-Brexit. Well, we've got still consent, although we know full well in the employment context that consent is not recommended as the only ground to rely upon because of the imbalance between employer and employee. And we know that consent has to be as equally capable of being withdrawn as it is given. So in the employment context, we probably rely on a combination of information to employees about data movements and contractual necessity, particularly where you are in a multinational group and it doesn't matter whether the data is pushed or pulled, there is an international transfer of staff or employee data. It could be that at the moment you rely upon an adequacy decision because it's Argentina, it's the Isle of Man, it's Israel, it's New Zealand, it's Canada, who are the recipient parties. That's fine, but as you well know, that list takes a while to grow. Japan has only just joined it in the last few weeks after many years of negotiating. Or it's Privacy Shield if the recipient is signed up to Privacy Shield, or it's SCC, standard contractual clauses, or binding corporate rules, or those seals or certifications and codes of conduct that I mentioned a few minutes ago in my flowchart. But what happens if we have an unnegotiated Brexit? What happens if on the 29th of March we are gone? Well, we might in due course get an adequacy decision, but if it took Japan X number of years and there's other countries like Turkey and so on in the wings, I'm not convinced that we will suddenly get an adequacy decision, even though the UK Data Protection Act 2018 incorporates all of GDPR, and even though draft variations on that exclude the words GDPR are on the books, so to speak, here, I just don't think an adequacy decision is going to happen sooner rather than later. We might get a deal, and it won't be a hard Brexit, and then there would be a negotiated arrangement that would probably put us like we were in the EEA, so a Norway or a Liechtenstein or an Iceland or some variation on that. And I think a lot of business people are hoping that that is the route that we go, that we get a deal that allows us to exit sensibly on the 29th of March, or maybe it might get extended, we'll see. Or you will rely on those other things like consent and necessity. But if we don't get a negotiated arrangement, then we have been told that we will be a third country. We will be like many, many other parts of the world. There's no adequacy decision. We might well have some great law, you know, and you're looking at Kenya and Bahrain and Turkey, South Africa, that are all mimicking GDPR style law, and yet they are still a third country, and we still have to have some contractual solution in place. And so I've put up there that it's going to be Privacy Shield if it's the US, or it's going to be standard contractual clauses, or BCR, or what I call an omnibus data transfer agreement. And I know that a good number of you on the call are aware of that concept. And I'm just going to talk about SCC, BCR, and ODTA a little more and see whether, in fact, any of those might help. So the quick solution is to have ready to go some contract between the UK entity and the EU member state entity that incorporates the standard contractual clauses, whether it's controller to controller or it's controller to processor, sub-processor. And that needs to be, if there were a hard Brexit, signed and good and ready to go, bearing in mind that in the UK we don't have to seek approval from the Information Commissioner's Office to that agreement. It would just need to be there and pulled out in anger. But that does need to be thought about. But that makes an assumption that the relationship is very two-dimensional. In other words, it's from, say, Sweden to the UK, or it's from Denmark to the UK. But for many of you that are on the call today, you're operating in multinationals where the data doesn't just go from one place to another, full stop, period. It moves in many directions, and in a multinational, it doesn't matter whether it's pushed or it's pulled, there is a transfer. So you could end up dealing with the UK with your different legal entities in different member states with a multitude of standard contractual clauses. That might be a lot of paperwork to deal with in a very short space of time, given that you've got to get a lot of detail into the schedules, the description of the information security policies, the different classifications of data, who receives it, why it's being transferred, etc., etc. You may be fortunate enough to be a company that has already got an approved binding corporate rules and to that extent you already have within a group of companies a mechanism that almost doesn't regard any one member or beneficiary of the binding corporate rules as an exporter or an importer. It is simply saying generically, where data moves from one member of the group to another member of the group, then here are the international data transfer rules and principles that we adhere to. And we have been blessed by the regulators on this BCR, so data can keep on moving whether the UK is in the EU or out of the EU. The ODTA, which I've been using for, since the late 90s, which was something that we spun off the International Chamber of Commerce data transfer agreement, which was subsequently what the European Commission adopted as the first set of model clauses. What we've done there is to do a framework agreement, which essentially for a multinational, for example, that can have one entity at one point, a controller sharing to another entity at the same time as a joint controller, or maybe one of the entities is acting as a processor because its system is being used for the benefit of the group. We've ended up saying that this is a group agreement, so that if at any time any one member of the group is acting as an exporter from a member state in the EU to another member of the group as a controller outside the EU, then it becomes an importer, and model clauses controller to controller at Schedule 1 are deemed to be incorporated and apply. It could be that the same agreement will say, and if at any one time an EU entity in the group as a controller is exporting to another member of the group as a processor outside the EU, then the controller to processor sub-processor clauses at, say, Schedule 2 will be deemed to apply. And you end up with one BCR light style agreement that is then signed by all the entities in the group across the world. So yes, one big signing ceremony, but we found more by luck than by design that because we never dictated that that legal entity in the UK was a exporter, or that that legal entity in another part of the world was a exporter, we simply say it is a matter of fact. That ODTA survives a hard Brexit because 1 nanosecond before the UK leaves, it's an exporter in the EU, and 1 nanosecond after the UK leaves, it's an importer. And yet the wording of the agreement and the standard contractual clauses survive that nanosecond change. So for a number of clients of ours, hard Brexit is not an issue because there is already a solution in place. We have a number of clients that are saying, actually, this might be a very good solution. Can we try and get something in place now? Because it would work whether we get a negotiated arrangement or we don't. But the challenge, of course, is getting the executive buy-in to do something before the 29th of March, when in fact it might be not necessarily the best use of resources if we get a negotiated deal. Because I suspect if it comes off in the next 18 months, we will find something that enables the data to flow, because data will continue to flow and the UK's law is adequate and so on and so forth. But it's not just about the data transfers. And by the way, thank you for the questions coming in. I've actually got a number in front of me, which I will come to, if you don't mind, when I finish the slides. What I wanted to do was move to the next slide and say, look, actually, there are some other issues that we have to think about in the UK if we don't get a deal. For example, what is our Information Commissioner's Office relationship going to be with the Article 29 Data Protection Working Party? We've always had a big seat at the table, been there with all of the other good discussion around guidance for everything from legitimate interest to data protection impact assessments to privacy by design or default and so on. But will we be there if there is no deal? And how will we find a way of influencing or in some way being consulted when we still trade huge amounts of data from the UK to the EU and receive from the EU into the UK? If you, for example, are a UK business that has no other legal entity in the EU, but of course do a lot of work with customers in the EU, because you may be in medical devices or life sciences or telecoms or just about anything. Given the extraterritorial nature of GDPR, remembering that if you are offering goods and services into an EU member state, whether for money or not, or you are carrying out monitoring insofar as the monitoring of subjects is in an EU member state, when the UK is not in the EU, we will still be caught by the extraterritorial application of GDPR, but we will have to appoint a representative in many cases. Where are you going to do that? Who is going to be that representative? Which is the EU member state where you have your most significant dealings? Will you in fact find that you have to have two regulators as a minimum, the UK, because that's still a requirement of the UK law even when we've left, and then wherever? Is it Sweden? Is it Denmark? Is it Greece? Is it Latvia? That will depend on each business to take a look and come up with a proper establishment point of view. And then for those of you that have looked at appointing representatives, there are organizations, we refer to some, who offer representative and outsourced data protection officer services, but there's not that many that are prepared to take on the responsibility. But that might have to happen 1 nanosecond after a hard Brexit. But have we thought about that one? Should we? Yes, please. I think you should. And the data protection officer, if we are mandatorily required to have a DPO, and currently our main operation is the UK, when we don't have a negotiated arrangement, we will have to have a data protection officer in another member state. And again, who's that going to be? Where is that going to be? Can we forum shop? Can we try and go for a jurisdiction that has a more commercially minded regulator? Or are we going to set up a startup office in Dublin because we think we want to deal with the Irish regulator? And will that really wash? Or will we find that actually when we have a data breach, we will end up having to deal with numerous supervisory authorities? Again, we're making this one, I shouldn't say it, but you know it, we are making this one up as we go along, all hoping that it isn't going to come to that. And who is going to be that supervisory authority? So it's not just about the data transfers that is the consequence of Brexit. It is the UK is no longer in the EU. Therefore, given that no doubt the UK office is doing lots of marketing and sales and service into the EU, you've now got the one-stop shop has gone for the UK when it is not in the EU, and that does need some thinking about and anticipating. Okay, and turning to the next slide, I was just going to say, of course, it isn't all about EU and GDPR and Brexit. We are inexorably moving towards a very similar regime in many, many parts of the world. The slide is already out of date in that I haven't added the state of Washington flag on there, who've recently published a very GDPR looking data subject rights looking piece of legislation. I just saw in the media this week that Microsoft are calling for a global GDPR style piece of legislation. And in case Americans have forgotten, we have Convention 108 as a global convention around privacy, which does have basic fair processing principles. We have the OECD guidelines that were updated in 2013 on international data transfers. So there is actually a general sense of direction already in terms of data transfers, data transfer mechanisms, and I haven't mentioned, but I should throw in the APEC mutual recognition regime, where again there are restrictions on data transfers in the Asia Pacific region, but not where members of APEC have agreed to mutually recognize countries with appropriate regimes. I don't think Brexit is going to be the end of data transfers. As I say, data will move whatever happens, but I think for businesses who need to be compliant with laws and regulations, it is a frustrating time because there is no simple answer. There isn't a tick box approach. My rule of thumb is at least be able to show a regulator that you were working on it, that you were moving in the right direction, even if you are not 100% right, because nobody is telling us what 100% right is. So I hope that you can take some of the things that I've been saying and make use of those, even though this could all change in another week's time. Anyway, I have a whole list of questions in front of me. I'm going to see if I can get through those in the next 5 or 10 minutes. Somebody's asked me, good question, by the way, are there any codes of conduct that have actually been approved? Interestingly, no codes of conduct under GDPR that have been approved because we still don't have the agreed approval mechanism between supervisory authorities. But there is an approved code of conduct that deals with all of the data transfers that's been around for many, many years, and that's FEDMA, the Federation, the European Direct Marketing Association, that because it was possible under the directive, created their own code of conduct many years ago, went to the regulators and said, bless this, because all of our FEDMA members have to abide by this standard. And yeah, if you want to see what a code of conduct looks like, go Google the FEDMA one. Many people refer to the GDPR instead of the Data Protection Act 2018 when putting in place contracts this year. Once we leave the EU, the GDPR will theoretically not apply. So should we be referring to DPA 2018 going forward? Good question and good advice. Yes, and in fact, the DPA 2018 references GDPR in many, many cases, and there is already a draft piece of legislation to make the removal of those GDPR references should we depart the EU one way or another. So no harm in referring just to DPA 2018 going forward. Once the UK leaves the EU, they become a third party. Has the UK taken the position, again, due to the Data Protection Act 2018, that standard contractual clauses will apply when moving personal data from the UK to another non-EU country, say South Africa. And how in the Data Protection Act is this provided for? Yes, well, there would be no harm in using the principles of standard contractual clauses to transfer data to other parts of the world. And indeed, in that omnibus data transfer agreement that I described, which we have run past regulators both in Asia, Canada, US, and the EU for many years, we know that those clauses do work because they adhere to generally international principles. How far do you think firms can amend standard contractual clauses in reliance on the wording which allows amendments in the proposed new schedule to the DPA? Again, I think the common sense answer is that the more that you vary standard contractual clauses, the less they are a standard contractual clause, and you may then have a problem with your EU counterpart in a negotiation, getting them to sign up to it, or they may turn around and say, we're not prepared to sign this until we have run this varied SCC past our local regulator. So I don't think there's much wiggle room there. In reality, we've lived with standard contractual clauses for many years. When we draft them, we understand the implications. I would not want to do any changes unless you can absolutely substantiate it and live with the risk that it may get rejected. What clauses should the UK controllers put in place with EU processors where the data flow is from the processor to the controller? There are no processor to controller clauses. Good comment, good question. My understanding of this is that we're the controller in the UK, subject to the Data Protection Act 2018, assuming that we've got a hard Brexit. We're using a processor in the EU. I would, by simply applying GDPR and DPA 2018 concepts, say, yeah, I would still take a controller to process a sub-processor set of clauses and work those into the contract with your EU-based processor. It keeps you compliant with the law, it's what you're required to do, and we know that the EU processor will be used to that style of clause, even though, as we've said several times in the webinar, up until Brexit, there has never been any hindrance, or not much of a hindrance, on intra-EU data transfers. Again, somebody's asked a very similar question about bringing data in, and I think the answer that I've just given to the similar question will deal with that. On contractual necessity for the transfer of employee data between a multinational group, the ICO guidance on this has said that this would probably not be necessary, but more of an issue of convenience, i.e. centralized payroll functions. What are your thoughts? So, yes, there is an argument that you have to have a contract with the employee, but it is the employer's choice to outsource payroll or appraisal systems or travel and expenses to third parties, and we've had those types of arrangement for a long time, and there's an argument that that is not a contractual necessity. It is the choice of the employer to use a third-party vendor, in which case to the extent that there's an international transfer, it absolutely pushes you to having standard contractual clauses, so that even though you may not have consent, you have at least adduced the right of individuals by the model contract. There is an argument you might rely on legitimate interests of the business if you'd carried out a legitimate interest assessment to show that you were not overreaching the rights of the employees. And of course, for many parts of the EU where there are works councils, you've still got to go through the negotiation with the works council or with the union representative before you can roll these things out anyway. A lot of those third-party vendors, of course, are privacy shield, so it's less of a problem for the EU than it is for the UK if we Brexit and are not therefore in privacy shield. Somebody's just said we're not a multinational, but we use a number of third-party suppliers. There are currently no standard contractual clauses to fit this situation. Good point, but that's what I think I would be looking at now, is thinking of due diligence questions for EU-based vendors as to how data is going to go between you and them, and again, adopting or adapting the model clauses is probably the right route to go. I've got, gosh, several more questions, and I'm conscious of Caroline needs a few minutes to say some closing remarks, but I'll carry on for another 5 minutes max. Somebody else has said, again, how do we deal with the lack of standard contractual clauses for these new situations that I'm describing? I'd like to think as well we will get some more guidance from the ICO if we end up with a hard Brexit. But again, go back to my rule of thumb, which is that I would at least be able to evidence that you are starting that thought process, that due diligence, even if what you put in place was not 100% right. The regulator is going to take into consideration the fact that you were moving in the right direction rather than burying your head in the proverbial sand and saying this is all too hard. Why does the DPO need to be outside the UK in the case of a non-deal Brexit? Well, again, your problem's going to be, again, extraterritorial nature means that you will be possibly subject to GDPR because of the large volume of clients or customers that you have in, say, Germany. You therefore have to have a representative to liaise with the German regulator. Let's assume that it's Germany, and then question, you will have to at least register your DPO with that German regulator, and this is where we're starting to guess as to what might happen in the event of a investigation into a non-compliant data protection impact assessment, or a data breach, or failure to respond to a German data subject request, that the regulator may say, how can the DPO in the UK that is not doesn't speak the German language, how is that feasible for them to be able to deal with a local issue? I can see that for many companies, and we've already done it for a number of our clients, where they are going, if we hard Brexit, Germany, for example, is going to be our only other office, but we only have 6 people in Heidelberg and they're all in sales, so no decisions are ever made there. Let's work with an outsourced representative and DPO company, because that might be the quick fix. Somebody's asked me what are the risks of not having everything in place given the low sanction frequency. Well, beware of the low sanction frequency. I think we are going to see some more significant enforcements and fines. So again, I think my rule of thumb of being on a journey is the right direction to be going. I'm just sorry for the silence. I'm just looking at what else I can take that is new. Are we likely to get updated versions of the standard contractual clauses? Absolutely. We know that has been on the books for some while, but of course other events are probably putting that for the European Data Protection Board and others just a little further down the agenda at the moment. But yes, I am sure that that will be happening. May we state versus the EU customer that the customer's acceptance of our terms and conditions of service will imply the acceptance of the standard contractual clauses. I don't see why, and in fact I can think of many contracts where that already is part and parcel of it, is that by agreeing to our terms of business, you agree to the model clauses at Annex A, which assures you of adequate mechanisms of the data being managed, whether it's you're the processor or they're the processor or your joint controllers. Okay, Caroline, we've got about 5 or 6 minutes before we get to the head of the hour or top of the hour. So do you want to just jump in here with a few words?
Thank you, Robert. Thank you for this excellent tour around the challenges, but also the opportunities. There are actually some in here as well. As I do have the possibility here, may I just ask you one question myself?
Okay.
I'm just thinking, what are your advice right now? There are so many challenges around the data transfer mechanisms and lots of focus on that in the various organizations. But apart from that, do you see an additional risk? I'm thinking, you know, in Sweden at the moment, we are seeing lots of headlines with regards to sometimes a lack of internal control within the healthcare sector. There is a breach that is being discussed. And with regards to internal control and monitoring of vendors and sub-service providers, I'm just thinking, what do you see here? Because even if we have a good transfer mechanism in place that actually would apply, let's say the SCCs, still, there might be a risk here. We might have to actually
Caroline, we just lost you there. And what I'm going to do is you're back, Caroline.
Hi. Yes. Sorry.
Sorry, we lost the last few seconds, but I think I'm gonna answer it. No. You make a very good point that in some respects the easy bit is signing the standard contractual clauses or developing the binding corporate rules or checking that the US vendor is Privacy Shield. The actual harder bit is living up to those warranties and representations that are made in the agreements. And I am sure that we will see crises, whether it is inability to respond to a data subject request or a right of erasure in the processor's hand, or it's the breach or whatever, where the regulator may say, you have said in writing that you do X, Y, and Z, and yet in practice, your compliance program doesn't come anywhere close. And so you have contractually lied, and therefore the fine and the consequences will be that much greater. And I also think we are seeing certainly a lot more due diligence now by controllers on the supply chain. And that's not just for data protection, of course, that's for anti-bribery and a whole range of other things, you know, modern slavery. But that's not as good as it should be in the EU. It seems to be a much bigger requirement in the US than it is over here. And that's, again, a reaction to the large investigations and FCPA sized fines over there. So I think you're right that it's not just about finding the contractual solution, it's actually living and breathing it. Caroline? I've lost Caroline for a minute. She may be on mute, but for those of you that are still okay, got you. Yes. Any other closing remarks before we finish?
Thank you so much. I'm sorry about the technical challenges. Thank you so much, Robert, for taking the time to discuss this. And I'm sure the discussion, of course, will go on. But we have lots of information here and lots of leads. And we are very grateful also for the very quick answers that you were able to provide. In the last 15 minutes or so, you've been taking lots of questions. Thank you about that. The presentation will be available also for the members of the Swedish Data Protection Forum. The presentation will be available behind login. So make sure that you have access to your login details. Thank you so much for today. Thank you for listening. Thank you to Robert and his team. And look out for more information from the Swedish Data Protection Forum. There are other networking events and webinars coming up eventually. Thank you so much. Thank you, Robert.
Thank you.